I'll do the presentation. That is, before that, good afternoon, one and all. Thank you for giving me an opportunity to present the paper in this prestigious international conference of GRCF. Myself, ZELEENA, working as assistant professor in Government Law College, Trivandrum. And actually, I was planning to do an offline presentation, but could not make it due to some personal inconvenience. But the organizers, the Prakash sir, were very supportive enough to give me an opportunity to make an online presentation. My heartfelt gratitude for the same. Today, I am intending to give a presentation on the topic legal provisions relating to sexual offences against women, implications of Section 354 of IPC. In the past few decades, the global rates of crimes have observed a rise that has been a matter of concern for the legal system of every country. India is one of the most popular countries, has been known for its diverse culture that attract global tourists and female entrepreneurs. However, criminal offences against women have been a major concern as the regional rates of crime like outraging the modesty of women, rape, eve teasing, stalking, have increased rapidly over the past multiple years. In this presentation, several cases relating to violence against women were discussed in relation to the existing legislative. In this presentation, several cases relating to violence against in relation to the existing legislative provision and especially amendments in Section 354 of IPC, further to the Criminal Law Amendment Act of 2013. Not only an overview of Section 354 IPC is also analyzed in this presentation. And moving on to the what is sexual violence. Sexual violence is quite depressing for society against any kind of gender. Crimes which are targeting the sexuality of women are characterized as sexual crimes or harassment, which include in its ambit psychological form also. Such harassment, apart from being a dehumanizing act, is also an unlawful intrusion of the right to privacy and sanctity of a female, to undo injustice done to women for ages, and based on the feminist jurisprudence, the Indian Constitution has empowered legislatures to enact special protective laws in favor of women. In reality, large number of such laws have been since independence. But this may lead to the conclusion that women in our society are enjoying a privileged position. But this illusion vanishes the moment starting examining with facts. India has experienced thousands of women abuse cases in the past few years, which reflects that the crime against the women are increasing, reveals that neither the education nor laws have changed the basic thinking regarding the women's worth and is looked upon as a commodity, merely as a commodity, and are victims of humiliation, exploitation, and torture by the men. Women within Indian villages are as well as urban areas are exposed to several threats, among which domestic acts of violence, sexual assaults, murder due to dowry, etc. are very common. Major reason behind this growing sexual offences in India is that women are ashamed to share their assaults. In most cases, girl victims are told by their parents to shut their mouth due to the fear of criminals or social stigma. During the pandemic of COVID-19, cases of domestic violence and sexual assault observed a rise in both rural and urban parts of India. Now, moving to the certain constitutional and legal provisions relating to women's safety in India. Our Indian Constitution contains express provision for affirmative action in favor of women as it seeks to prohibit all forms of discrimination against them and secures equal opportunity to them in every walks of life like education, employment, political participation, etc. Principles of gender equality are enshrined in our fundamental rights, Article 14, 15, 16, 21, Article 38, 39, 42, Direct Principles of State Policy, Article 51A, where the fundamental duty of every citizen to renounce practices derogatory to the dignity of women. And penal statute of our country also plays a very significant role, that is giving significant importance to sexual crimes, and provisions under Section 354, 354A to D, 294, 375, 376, 509 of the Indian Penal Code are dealing with the sexual offences against women. And there are also several legislations like Indecent Representation of Women's Prohibition Act, Immoral Traffic Prevention Act, Protection of Women from Domestic Violence Act, Sexual Harassment of Women at Workplace Act, and Criminal Law Amendment Act 1938, which is otherwise known as the Nirbhaya Act. So it is seen that not only the legislature, but the judiciary also plays an important role in the case of women empowerment and sensitize the judiciary. A judiciary which views the circumstances and situations in a holistic manner can contribute much towards women empowerment. In the famous case of Bodhisattva versus Subrata Chakravarti, Supreme Court has held that rape as a crime which is offensive to the fundamental right of a person guaranteed under Article 21 of the Constitution. And in the 2012, the most famous Nirbhaya case, Mukesh versus NCT Delhi, it shows the country's conscience and existing legal framework safeguarding the rights of women. The incident aroused unprecedented media and public attention and was widely condemned throughout India and abroad. And due to the public protest, a judicial committee headed by former Chief Justice of India, J.S. Verma, to present a report within 30 days to put forward amendments to the criminal law to strictly deals with sexual assault cases. The report states that inability or non-serious attitude of the government and the police were the main reason behind crimes against women. And in 2013, this Criminal Law Amendment Act was promulgated by the government. And now, moving on to the efforts on let us have a perusal of what are the efforts at the international level regarding the sexual violence against women. UN Charter and the UDHR is considered to be the foundation of the international human rights law, and the International Covenant on Civil and Political Rights, ICCPR 1966, International Covenant of Economic, Social and Cultural Right 1966, etc. deserves to be specifically mentioned. And the convention of CEDAW convention, this convention on elimination of all forms of discrimination against women, CEDAW, and which is a basic instrument in the sphere of international law, which accorded primacy and supremacy of the woman's human right. And 1975 to 85 is declared as an international decade.
Hello, yes. Can you come to the conclusion so that you can conclude with your suggestion? No issue. Okay. You have covered almost all legal provisions like and IPC provision 354 ABCD and the other provisions, IT Act and other acts. So can you please come to the conclusion of your presentation with the suggestion?
Okay, that is, I just was mentioning that 3000 amendment introducing Article Section 354 A, B, C, and D, and what is that? And also the state of Punjab versus Major Singh, where the Supreme Court has defined the concept of modesty, and the Ruban Diol Bajaj versus KPS Gill case, and this 4 offences were added in the Indian Penal Code. The sexual harassment, then disturbing the woman, voyeurism, stalking, etc. And again, after that, this 2018 Amendment Act, which resulted as a result of Kathua rape case and also the Unnao case, which has resulted in the amendments of 2018, which amended Indian Penal Code, CRPC, Indian Evidence Act, etc. And what are the main challenges which is faced by the prosecution, the sexual assault cases, that women have that is the social stigma is associated with it. So the people are not coming forward with the this kind of offense, even if it is committed, because of the social stigma and because of out of ignorance, illiteracy, and the fear of retaliation, they are unable to access to the police. And even the police, if the persons opposite accused persons are very influential, police tries an out of court settlement. And also this, even our judiciary has suggested marriage as some kind of, marrying between the man and the rape is okay. That attitude of the judiciary. And so this is something which the court has clearly stated, that this kind of social stigma and the attitude of the society towards this kind of sexual offenses is a major stumbling block. So there should be effort from do this. Otherwise, whatever legislation, whatever judicial decisions, and however we come out with this kind of crimes are increasing. So this is what the attitude and the towards of the society. And so it is a duty of the state to foster such a climate and also to make available such resources that enable the victims to file a complaint. And police officers should be completely sensitive.
Okay, good. Enough.
Okay. Once again, thanks to the organizers, Prakash sir, Krishnamar sir, Dinesh sir, for all
this opportunity. Nice presentation.
Okay, thank you.
So Do you choose to make any more statutes in addition to sexual harassment at workplace act to cope up with the
Yes.
present situation?
Yeah, there is a
Do you have suggestion that
uh,
any other legislation, any other legislation other than workplace act is required, or do you want to make any amendment in the existing law? Which is your suggestion?
new legislation
Which is
is not required. 2000 Act
ah,
is covering the act that is this sexual harassment at workplace, but there are certain areas, gray areas in that topic. That is only the woman, that the sexual harassment of the against the woman at workplace alone is considered. It is not considered considering about the that is LGBT community or other persons who are also facing such kind of sexual harassment at the workplace. So it is, this act is specifically only for the woman purpose. So that kind of faults are there in the section 30, this sexual harassment act. So some amendment to remove all this one, it will be more good. And there is no provision in the act to take action against those institutions which has not the taken steps. So if they have not dealt with this side of complaints properly, like that. So that kind of this implementation wise, we have to look upon some amendments to make it more stringent.
do you think that very often this law is being misused rather than being used?
Yes, of course, of course.
So they make in the guise of this act. Do you have a feeling like that?
Yes, of course. I do have an opinion like that because many times it is used by the persons for getting some benefits and like that. So there must frivolous complaint or to deal with that, there should be it should be clearly strictly dealt with under the provisions.
The main problem and one important problem identified in my thoughts is the stigma faced by victims of sexual harassment.
Yes,
So the
yes.
proper implementation of any sexual harassment legislation is hindered by the victims or what to say, we are now addressing not with the term victim, it is now survivor, adijivida എന്നൊക്കെ പറയുമല്ലോ. അപ്പോൾ any special measure in your opinion required for protecting
That
the
is attitude towards,
person who is subjected to
because
sexual harassment, the woman who is
Ah.
in the receiving end? Any special
Yes.
measures in addition to the witness protection laws to avoid the stigma and keep the victim or the survivor safe, enforcing all her rights? How can we address this issue?
Actually, yes, it is big thing because it is usually every time this kind of stigma is what is forcing the actual persons who have who had experienced such kind of sexual attacks from approaching the authorities. Because even and the attitude of the society, even our judiciary recently also in one decision, that is marrying the part between that is a accused person and this victim. If there is a marriage, then all the what are the crime which has been done against them is condoned with. That kind of attitude even judiciary is showing. So that is victim. These victims are again victimized, and the police, everybody is trying for a compromise only. And if the persons are influential, then otherwise this girl has to, even though this consent theory, only the lady's consent is important, but that consent and all, even though legal provisions we are making, but still the fact remains that she has been victimized again and again. That is, her character is being as introspected, and all these kind of things are so only the attitude of the society, that is, this is something a shame for the woman. That kind of that attitude, only if it is removed, then only there will be any solution for this problem.
Even authorities, not only the public, general public, even authorities have the same kind of attitude.
Same
especially
attitude.
when a sexual harassment complaint is entertained by an internal committee, the committee will go for inquiring the history or the antecedents of the victim and take a point that she has been in good relationship with the perpetrator. She has gone out with that person in the past. So that kind of considerations, and they allege a permissive behavior on the part of the victim, and they try to weaken the case.
Yes, yes,
And
yes.
the principle of criminal law is the history of the victim is immaterial.
Immaterial.
Even if
Evidence.
she has been, even if she has been having consensual relationship with the person in the past, if the present issue in question is without consent, it is a culpable offense.
Yes, yes, yes. Consent
But
here.
our yeah.
Yeah.
Hmm.
Yes. Yes.
Okay, thank you, ma'am, for
Okay.
your insightful presentation.
Okay,
Keep in
thank
touch.
you.
We
Thank
were expecting you here, but we are informed
But
that you had some
unfortunately, due
inconvenience.
to some personal inconvenience, I couldn't make out. Otherwise, I was
Okay.
also planning to come.
Okay.
100% I was planning to come.
Okay. Thank you,
Okay.
ma'am.
Thank you.
Take.
Thank you.
Bye.
Thank you. Take care. Take care.